part of the regulatory world easier for you. All right, let's go forward. I'm trying to move this forward, Eva. Oh, there it goes. Okay. All right, so today we're going to give a quick overview about what is LNI and then move to those to 6 different essentials for small business. All right, so LNI is a house, if you will, of many, many programs. The state legislature passes laws and then needs to put them somewhere, and these are the programs that are housed in LNI. We have a motto to kind of incorporate all of that, all of what is LNI together. We use a motto of keeping Washington safe and working. So you'll see from a lot of the employment laws to electrical and elevator permits. We permit taco trucks and have crime victims compensation programs and things, a lot of different things that you may not be familiar with and may not impact you, but just as an FYI. All right, so let's move to the essential number 1. Understand who's an employee versus who's an independent contractor. So a little background on me. For most of my career, for about 15 years of my career, I was a small business advisor and the director of small business programming for some additional years. I'm starting with this essential because I met with literally hundreds of business owners over the years who didn't realize they were employers, but they were actually, at least based on the law. In many cases, they thought they were engaging independent contractors. Well, there are independent contractor tests in several laws, including those with the Internal Revenue Service, the IRS, the Federal Department of Labor, Washington Employment Security Department, as well as the Department of Labor and Industries. And in some cases, an independent contractor may meet the IRS test, but may not meet LNI's. LNI's is one of the stiffest tests. So the way it kind of works is people who work for you will be considered your employees unless you can prove otherwise. So how do you prove that? These are some of the questions to ask. Do they bring more than their personal labor to the job? If they're bringing their own staff, if they're bringing major equipment, bulldozers or something, that would mean they would be, in fact, independent contractors. Are they working without your supervision, direction, or control? They're doing their own thing. You've hired them for their expertise to do it their way. Are they doing something different from you? So if you bring in someone to work in your retail store who is doing what you would have done at the retail store, that isn't something different. But if you hire that web designer for your retail store, that would be something different. Do they have an established independent business that markets itself and files business taxes? So are they operating as a business? That's part of the test. And then just again, that statement that LNI's test is stricter than the IRS. So many of your accountants are focused on your federal income taxes, and they're looking at IRS definitions. So don't necessarily trust that they're thinking about Washington. If you're curious of whether maybe you have someone working for you who you're wondering, do they fit this or not? We do have a determinations unit at LNI that can help you determine that. So that's a phone number and a website for that. All right, LNI essentials for small business number 2. Understand the basics of workers' compensation insurance in order to manage costs and impacts. So one of the things LNI does is cover workers in the state of Washington for work-related injuries. Workers' comp is kind of a promise to both employees and employers that if there's someone injured on the job, they'll be taken care of. They'll get medical care. If they need to be off work, they'll get wage replacement. They might have to be retrained if they're injured severely, so there may be vocational services there. So they'll be taken care of. Employers won't be sued. And in this state, we have a no-fault system that we don't look at, did the employer do something? Did the injured worker do something? It's just assumed that if they're a worker in Washington, they're covered with workers' comp that is handled by the Department of Labor and Industries. So workers' comp is an insurance in its structure. What I mean by that is the calculation of the amounts are as they do with private workers' comp carriers that are in other states. So we're looking at what were the risks, what were the costs, what is the basis for the fee, and that's where premiums come from. How do rates work? Well, I have these two cars here as an illustration. So workers' comp comes primarily from two places. One would be comparable to what kind of car do you drive? Are you driving the beater or the hot rod, the fancy, expensive hot rod? And this would be comparable to what kind of work is someone doing. If I'm sitting in my office working with my computer, it's a pretty low risk world. That would be more like the low cost car, versus I am felling trees or I am working in a pretty heavy manufacturing situation. That would be a more pricey thing to insure. Then on the experience factors, the other primary piece, that would be how am I? Well, the analogy would be, how am I as a driver? Am I a very careful driver, or am I that 18-year-old who loves pushing down the accelerator? So that experience factor is what is the history of that particular business relative to other businesses that do similar things. So they're looking at that employer itself. And the rate is pretty much the calculation of a base rate, what kind of car, times the experience factor, how am I driving? So that's where workers' comp rates come from. So let me show some of the impacts of experience rating. If you are, what I'm going to do here is compare two companies that both have 10 full-time employees. One is a roofing company, so you can imagine a higher risk. One is an accounting firm. They both have the same number of hours per year for employees. So if we look at that roofing company, the base rate per hour, this is the cost of workers' comp per hour, is $5.96. So for every hour an employee works, the employer is paying $5.96 to the Department of Labor and Industries. A portion of that can be deducted from the employee's pay, but most of that is borne by the employer. If I'm a new roofer, my experience rating is going to be a 1, and that acts as a multiplier on the base rate. Well, a multiplier of 1 is going to mean that we will be paying the base rate. So if you can see where the multiplier is 1, my company is paying $114,000 of workers' comp per year. If I have very good experience, so that I have few injuries or illnesses, occupational illnesses, then you'll see my rate goes down, potentially in this case to 0.75, my experience rating, to $85,000 a year, almost $86,000 a year. On the contrary, if my experience is poor and my experience factor goes up, my workers' comp rate for the year, workers' comp cost per year, is now up to $223,000 a year. If I am a roofing contractor and I am bidding on contracts, it's going to be hard for me to be competitive against the other roofing contractors. I have such a higher cost than they do. So for that kind of company, workers' comp matters greatly. Then contrast that with that accounting firm down below, where the accounting base rate is about 16 cents per hour. So way different than the $5.96 an hour. So same deal, if I have 10 employees, 19,000 hours a year, you'll see the difference between a good experience factor of 0.75 and a not so good one at 1.95. And the difference is, we're looking at about $3,000, which is real money to a business, but it isn't likely to impact their competitiveness. So just an illustration that if you are in a field where you have higher rates, workers' comp costs will really matter to your bottom line. So how do you manage workplace injuries? The best thing for you to do is to be highly engaged. understand all the legalities and deadlines and things so that you're making sure that you're not losing control of the claim. Be involved immediately. Stay involved. You have full access to medical records. This is different than your usual medical world where you can't. You're not going to be able to get someone you know's medical records. That they have to do that themselves. Well, when it comes to workers' comp, the employer has access. And then there are plenty of options for mitigating the impact. A primary one here at LNI is Stay at Work, where LNI helps to pay your costs to bring an employee back to a light duty job if that can work for them. So maybe they're not ready to come back to their previous work immediately, but we will help getting them back because that really matters in the long run for getting work, having workers resume their health. All right, next slide. So understand employer wage and hour laws. So we're going to go through a whole bunch of employment laws. Just want you to be aware of these. And if you have questions on any of these, you can certainly ask them now or also address them to me later or look on LNI's website. But we'll just run through some of them so you have a sense of your many responsibilities as an employer. Minimum wage. Right now, the minimum wage is $12 an hour, but it goes up to $13.50 in 2020. If you're in Seattle, City of Seattle, or City of SeaTac, you will have a higher minimum wage than that. Unlike in some states, tips are on top of minimum wage. There are some states that let you get tip credit as part of that minimum wage, but not in Washington. Tips come on top of that. Employers can't take some of those tips. If there's a tip pool, the owners of businesses, exempt employees, those who are not eligible for overtime, they can't participate in that. If you're going to employ minors, meaning people under 18, you'll need a minor work permit, which you can get through the Business Licensing Service, Washington's Business Licensing Service. You also need to have a completed form, parent school authorization form for each of your minor workers. And then be aware that minors are not able to do all the same things or work the same hours. So there's resources on the LNI website to tell you what are those restrictions. There are many folks who have some misunderstandings about interns. In the for-profit world, there is not a such thing as an unpaid intern. If you have an intern working for you, they either have to be receiving school credit, like they're doing this, they're going to school at St. Martin's or South Puget Sound Community College or University of Washington or whatever, and they're getting credit for this, or you are paying them and paying them minimum wage. So just an FYI. Also, this is true of volunteers. People misunderstand that they can have friends or family working for them. That's not a legal practice. There's not an exemption in the law for people who love you to volunteer for you. So just an FYI. Some more wage and hour laws. Employees are required to be given breaks, at least 10 minutes within a 4-hour period. Employees can choose to have intermittent breaks, or you can allow them to have intermittent breaks if they want to, take a phone call here or there or do some texting. They don't have to necessarily take the 10 minutes all at once. Meal periods, you need to provide at least 30 minutes during a 5+ hour shift. You don't have to pay for meal periods as long as they're fully relieved of their responsibilities. Payroll deductions. Obviously, as an employer, you're required to do some payroll deductions for Social Security, Medicare, other types of taxes. But for other things, medical benefits, health care, or health fitness center dues or whatever, you need to have written consent by employees to do that. You're required to have workplace posters put up. LNI requires 3 of them, which are available on our website for free. And then other state and federal agencies, including Employment Security, the Equal Employment Opportunities Commission, and others require them as well. LNI has a website or a publication, workplace posters, that describes some of those and tells you how to get to them for free. Watch for scams. This is a great one where people tell you that you need to pay them $100 or something, or $500 or whatever for workplace posters. Those are all available for free. If you have workers who are not physically in a workplace, I recommend emailing them the posters and doing that periodically. So, every 6 months or so, just ensure that they have been provided notice of those things that are on the posters. Overtime pay. So overtime pay, meaning time and a half for all hours over 40 in a week, is required for all workers unless they are specifically exempted in the law. And let me say that comp time, some employers misunderstand comp time. You must pay time and a half overtime if the hours have crossed over into the following week. You can have comp time if it's in the same week. For example, today I worked 10 hours, so you give me a couple hours off tomorrow. As long as it's in the same week, that's okay, but that isn't okay if it is in a following week. Common exemptions from the overtime, the most common is that white collar set of white collar exemptions. These are for executives, high-level administrators, professionals, and outside salespeople. In order for someone to be exempt from overtime under the white collar tests, you need to review the requirements for the executive, administrative, professional, and outside sales. There is a description of what those are on our website, so you'll want to make sure that the job that your employee is working in does truly reach that description. And then there also is a salary test. You need to be paying them the same amount every month, regardless of whether they work overtime or undertime. So if they're taking time off to go to their kids' concert at school, or they're coming late because they slept in or whatever, you don't adjust their pay. And then there's a salary minimum. Currently, it's established in federal law at $23,660 a year. That's the annual salary. In 2020, the federal minimum rises to $35,568, so someone has to have at least that salary. And then going forward, LNI is in the process of rulemaking, and we're going to be concluding that in December, where we're going to be changing that minimum now in state law so that it will be a multiplier on minimum wage. That multiplier will be increasing over the course of years until, probably 2026. It's possible it'll extend another year or two, to be 2.5 times minimum wage. When at the point where that comes into play, that will be about $80,000. So no one will meet that white collar exemption from overtime unless they are at a salary of $80,000 plus, assuming that rule goes through, and I think it's very, very likely to. All right, I believe that there was a Let's Talk Business about the paid sick leave requirement, but I'm going to just quickly go over this. Employers are required to provide paid sick leave to employees, and it's an accrual rate of 0.025 hours of sick leave for every hour of work, or another way of saying that is 1 hour of sick leave per 40 hours of work. And this is for part-time and temporary employees. When they're hired, you must provide them notice of that, and there's a sample of that notice on our website. And then you must provide regular updates of what their accrual is, what usage has been, and what their balances are, at least monthly. You need to start accruing immediately upon hire, but you can require that the employee work 90 calendar days before they're able to use their sick leave. Sick leave can be used for their own illness or healthcare appointments, or for their family. And there's a broad definition of family. So if you have some question about, does this family member meet the requirement, or are you required to provide it, you can certainly be more generous in your policies. But if you go on our website, you'll see those definitions. And then also, employees need to be allowed to use their sick leave, paid sick leave, for school and daycare closures due to health, and any needs related to domestic violence. From 1 year to the next, the employees are able to carry forward their balance at least up to 40 hours, and then the accrual would build from that balance. If you have written company policies, it provides you a little more latitude and more control. For example, if you want to require that employees provide notice of appointments for themselves or their family that they know are happening in the future, you can do that if you have a policy that says that. Also, if you want them to provide documentation of any illnesses that last longer than 3 days, again, you have to have that in policy. So you can't just ask one employee to do that if it's not a policy that you apply to your entire staff. Okay, and you don't have to cash out sick leave at termination, but you must reinstate it if they're rehired within a year. Okay, so the Equal Pay and Opportunities Act. You must provide equal pay and advancement opportunities without regard to gender. And some new provisions to this law that are recently in place is you can't require that your employees keep their salary or wage confidential. If they choose to speak to each other, that's their right to do so. And when you're talking to applicants about jobs, you can't ask for salary history. The purpose of this is that for folks who have been historically underpaid, it would be common for employers to build their new job salary based on what they've had before, but that perpetuates that underpayment. So you'll need to pay them based on the job you will hire them into. If you have more than 15 employees, there's a few other provisions there that I listed. A law that goes into effect in January affects some people who are working in isolated situations. This was legislature dealt with this because of hotel and motel workers, primarily folks that were in vulnerable positions with hotel guests who may have taken advantage of people or made the people feel at risk. So if you have any isolated workers, there are some special provisions there that you'll need to follow, but I list some there. The need to have a sexual harassment policy, some special training, special resource lists, and then a panic button so that they have a way of getting help. And finally, in the wage and hour laws, oops, I see I double worded laws there. Non-compete agreements are being highly limited effective in January. You can have non-compete agreements only with employees who earn at least $100,000 or more a year, and that will go up with inflation, by the way, from year to year. Or if you have independent contractors earning more than $250,000 a year. And non-compete agreements can't extend more than 18 months beyond separation. As you'll see there, it doesn't affect other agreements such as non-solicitation, confidentiality, non-disclosure, etc. Another law is related to outside employment. So you're not able to tell an employee they can't work at another job or have their own business unless you pay that employee at least 2 times the minimum wage. You are able to say they have to work these hours for you. So, I mean, it doesn't affect your ability to restrict. Let me say, you can restrict their outside employment if it affects your scheduling or if there is a real conflict of interest with who else they're working with. And then finally, record keeping. I'm not going into the details here about what records are required to be kept, but you need really strong records as an employer. If you don't have good records, then as I note here, the employee's view of an issue is weighted way more heavily than yours. And we will estimate workers' comp premiums on you or for the business that may or may not have any relation to what really happened, but with the absence of records, that's just the practice of not just LNI, but other employment regulators. All right, so essential number 4, you must have a customized, written, communicated, and practiced safety program. There's more to keeping workplaces safe than most businesses realize. So let me back up a bit and just say that worker safety and health is administered by LNI's Division of Occupational Safety and Health, or what we call DOSH. And DOSH is administering both federal law, the OSHA, Occupational Safety and Health Act, federal law, and the state Washington Industrial Safety and Health Act. DOSH develops and enforces safety and health rules, and by the way, there's something like there's over 10,000 safety rules, so it's a very broad set of law. And then DOSH enforces the rules by inspecting work sites, and we inspect work sites without notice, so these are surprise inspections, unannounced, I should say, inspections. And then DOSH will investigate serious incidents, any worker complaints they received about safety and health, and also they will investigate places where a worker feels they've been discriminated against for reporting safety concerns. So an accident prevention program is that written document that is required. DOSH considers it a serious safety violation if you don't have a written accident prevention program. And if you don't have one or don't have an adequate one, you will be fined if you're inspected and don't have that. It's serious. To create a comprehensive program requires a lot of thought and effort. LNI has great resources. However, sample programs, tips on identifying safety hazards, resources for safety meetings, and probably the best thing we offer is the DOSH consultation service. So back again to there being something more than like 10,000 safety and health rules, there's no way that you can know all of them that apply to you. I mean, it's just not possible if you're doing anything else to run your business. So employers are crazy not to take advantage of this free resource where a very helpful, knowledgeable person will come at no cost and talk with you about your program, help you identify those hazards, tell you about the rules that apply. There is no risk to you for them coming. If they find a serious hazard, you'll need to fix it, but you won't be cited for it, you won't be fined for it, and so there's no risk to your bringing them in. We have some different types of consultation. You'll see their safety, industrial hygiene, ergonomics, risk management. When you go to that website noted there, or you call LNI, we can help set you up with the one that makes the most sense for what your business is or what it is you're trying to accomplish. I thought I'd show here an example of a citation from DOSH. Here's an employer. I should say OSHA, the federal law, requires that DOSH cite serious violations, and they also have to fine, so citations and fines. So LNI doesn't have a choice whether or not it cites you or charges you. Here's an invoice a business owner I recently worked with received. Many people who call me after they have had an inspection tell me that how much they would have gladly met the requirements if they'd just known about them. Why don't they get a warning? This just seems really harsh. Is there anything I can do about it? And me as the LNI's small business liaison. But there's not, because again, it is in federal law, also in state law, that fines be levied where it's serious violations. So that consultation service is really valuable. Other DOSH resources, as I've mentioned, extensive websites, sample safety plans. So if you're wanting to develop your program, you'll find samples, Word documents that you can update for your situation. Lots of trainings and workshops, meeting ideas, videos that can be really helpful to your employees, etc. Another thing I might add, that even if your employees have been trained and you have policies against them doing something they do, if they're injured on the job, they will be covered. So that can be frustrating to employers who have been very careful in how they have administered their safety program, and yet they still will have the impact of a workers' comp injury in some cases. It's the and that because again we're a no-fault system for workers' comp. Okay, LNI essential number 5. Know if you're a contractor and follow the rules. This is construction contractors that I'm going to be talking about, and contractor compliance is another program of LNI. So there's a broad definition of contractor. In addition to your roofing contractor, your framing contractor, your flooring folks and all that, it also includes developers, some types of construction consultants, and house flippers, folks that are residing in a house or they bought a house to convert and then they're going to sell it. It also includes some janitorial, landscaping, garbage hauler, computer network, as you can see, all these, and handyman businesses. So let me give an example. A janitorial service, just cleaning up an office building at night, that wouldn't require a contractor registration. But if they clean up new construction, it would. A landscaper who's mowing lawns and trimming hedges wouldn't be required to, but that same landscaper who's now cutting down major branches, building paths, building flower beds, they would. So all of these have include some these categories can kind of fade over the line. I shouldn't say fade over. Step over the contractor required. Excuse me. Those required to have contractor registration. So if you have questions or you're in that world, let me know, and I'd be glad to help tell you where that line is. With with construction businesses, back again to my experience as a former business advisor, I knew many businesses who didn't want to pay for the cost of bonding, registration, insurance, and all the things required for contractor registration until they felt confident they had a job that would help them pay for all that. But that's not how it works in the contractor compliance rules. You have to be fully registered before you can even solicit business. And your marketing materials must include registration information. And realize that if you're a general contractor hiring other contractors, they may be considered your employees or covered workers, in quotations there, for workers' comp purposes. You'll want to make sure they meet that independent contractor test we talked about earlier. If you have contractors who are not covering, if you have subcontractors who are not covering their workers properly for workers' comp, you could be held liable for that. So you'll want to make sure you're working with very credible subs if you're a general contractor. And now for my last essential here, seek information and ask questions. It's actually really great that you are on this phone call. It also tells me you are connected with the Washington Center for Women in Business. You are seeking information, and that will serve you well. That kind of thinking is really valuable for being successful in business. This is showing where you can get assistance from Labor and Industries. This is showing where there are field offices, and you can go into those locations. Or you'll also see my office's information there where you can call or email. I'm in the Olympia area, but I work all over the state, so you're welcome to contact me and the others in the Small Business Liaison Office or any of the LNI office service desks. Lots of online resources that are available 24/7. Let me say that we have just launched, as in Monday, launched a brand new website for LNI, and there are some bugs in it. So please bear with it if you're finding some things aren't connected right. Give us a few more days, and I think we'll be back in good shape. But there are lots of LNI resources available to you all the time. So as you'll see the list here, extensive employer informational resources, Q&A pages for how do I handle this, how do I do this, tell me about this. Lots of access to the laws, rules, and policies if you want to see the sources of our activities. workers' comp account information, payments, claim portal, and then you'll see the bottom one there I list as verify, and that one's so important that I want to show it to you. This is the new homepage for LNI, and on that homepage I have circled here where it says verify a contractor's or tradesperson's license. This is really verify a business or get information about a business. So if you click on that, you will get to a page where you're able to enter your UBI number, your name, your business name, or that of your competitor or that of your friend, any business name, and bring up some information about them. Here I have a business that's brought up, and it tells, you'll see under where it says workers' comp, it lists the account number, it lists who their account contact is. That person is effectively the insurance agent, the workers' comp insurance agent. So if you ever wanted to contact your workers' comp insurance agent, their number's right there, their email's there. And then enlarged over on the right-hand side, you can also look at what are the workers' comp rates. So if you're not recalling your rates, or your experience factor, you'll see this one has an experience factor under 1, so that means they've done well in managing their workplace injuries. And then it also shows the hourly rate for their risk class, 35 plus cents an hour, and then the amount of that can be withheld from the employee, in this case 11.6 cents an hour. It's also a way to get to your certificate of workers' comp coverage, and that shows right there. Verify also shows things that aren't necessarily things you would like the public to see, but they are there publicly. In this case, you'll see circled there an experience factor that's over 1, so they've had some injuries. If you have some concern, well, let me say prime contractors often have concern about their subs having higher experience factors, so that would not be something they'd like to see. Then further, what you see on the left-hand side, you'll see they have some citations, safety and health citations. So that's there for the public to see. So just an FYI, what's on Verify is good stuff and helpful stuff, but also some revealing stuff that could be embarrassing to a company. All right, and that is the extent of what I have to say. I have here our card. This is normally a business card size deal, but shows me and the assistant liaison and how to contact us. And we're really happy to help you with any questions you have about LNI or questions you have about state government in general and are not sure where to get the help. Happy to provide assistance to you in whatever you need. All right, well, are there any questions or comments?
Yes, thank you so much, Celia. That was really great. I probably will have a question, but I do want to open it up to both Dina and Karen and allow you both the opportunity. If there's any questions that you want to follow up, you can either raise your hand or type in the question, but given that it's a small class, I can unmute you. So if you raise your hand, I can unmute, and then you guys can go ahead and ask your questions. But I'll go ahead and ask my question while we're waiting to hear back from either of those two. Is that I kind of want to go back on the new law that will be going into effect in regards to overtime. So if I understood correctly, even though you may be salaried, and let's say you'd have to be salaried over $80,000. If you're salaried and under $80,000, then you would still be eligible for overtime.
So let me say that. Okay. So thank you for asking that. That's a really good question. So you'll see that number there for 2020 is in place. The federal law is higher. So let me back up. Where there's federal law and state law that are different. The law that's more favorable to employees is what we follow and what you as businesses will need to follow. So currently and for 2020, the federal minimum of $35,568 will be controlling. But what's going to happen with the new Washington rules that are coming into play, assuming they go into play, and like I said, the rules are expected to be finalized in December. In July of 2020, the new Washington rule will be that the salary minimum for Washington will be 1.25 times minimum wage. Well, minimum wage and that number won't be more than the federal. So the federal law will control all of 2020. In 2021, the multiplier on the minimum wage, oh golly, I don't have this in front of me. I believe it's 1.5 in 2021. Don't quote me on that. I will be happy to give you further information later. But for 2021, 1.5 times minimum wage. Let me see what that would be. So minimum wage is going to be $13.50 times maybe 0.1, maybe 3% inflation times 1.5 would be Joe, I did something wrong. 13.5 times 1.0.
So then the way that it's written, because I'm just going off what you had initially said, so you were saying you threw out 80,000. But if we're going to go by the feds, so anything over 30, according to the slide that you have there at 35,568 for 2020, so anyone making over 35,000 pretty much would be eligible for overtime next year, July.
Anyone who makes less than 35,568 in 2020 will not be exempt from overtime. Anyone who makes more than that, potentially they could, if their job meets the duties test, if the employer doesn't subtract for time away. So if those other things factor in, they may be eligible then for that white collar exemption. In 2021, the multiplier on minimum wage, I believe, is going to be about 1.5. And then in 2022, it'll be a little higher. 2023, a little higher. So that when we hit 2026, January of 2026, that will be the conclusion of phasing this new law in. And at that point in time, unless someone makes about $80,000, that's based on what we think minimum wage will be, because from this point forward, minimum wage will be rising with inflation. So each year we will be recalculating minimum wage. But based on the expected inflation rates and such, in 2026, unless a worker is making about $80,000, they will not be exempt from overtime.
Okay. That makes sense.
Watch the website each year to find out what that number is, because again, it'll be based on minimum wage, and that's going to have an inflation factor establishing it. And then it will be based on where is the multiplier as we are phasing it in. So phasing it in with 1.25 times minimum wage, 1.5 times minimum wage, 2 times minimum wage, et cetera, all the way up to 2.5 where it is set to end. From then forward, it will be just 2.5 times whatever minimum wage is.
And then, of course, as a small business perspective, I mean, if I'm the owner and I'm just myself, I don't necessarily, it's up to if I want to do that or not, because I'm just paying myself, correct?
Oh, correct. Yes.
Business perspective.
A business owner is exempt from the wage and hour laws.
That's correct. Right. Okay. Well, great. Thank you for that clarification. I think Karen said she was good. Dina, are you okay? I haven't heard from you. Sean, did you have any questions? No? All right. Well, I want to thank you so much for taking your time, particularly during this lunchtime, and we really appreciate. This was very enlightening, Karen said, so she's thankful for all the information. I will follow up and provide everybody copies of the slides via email. And in that email, please don't hesitate to respond back and let me know if there's any other topics or areas that you would like us to cover in the future. That would be very helpful as I begin to schedule out my calendar for 2020. So at this time, oh, Dina is saying she wants to speak. I'll go ahead and unmute you, Dina, so you can speak.
I just wanted to say thank you for all the information. It's a great help.
You're most welcome, Dina.
All right. Well, thank you, everybody, and I hope everybody has a lovely afternoon. And Celia, I'll give you a call later.
Thank you so much. Bye-bye.
Thank you, everybody. Bye-bye.